Man, that's not good. Can you guys like take a picture and send me that? I'll send it to the publisher and tell them to like fix that for the next edition.
I think what they're going to say is it'll be more expensive.
All right, 7:30, 7:30, let's go. Ready? I am glad all of you made it. We will have a wonderful class today. Yeah, that's fine. That's fine. Take your time, so you don't have to run.
It was hard to get here, though.
Oh, well. I am grateful you're all here. I was talking with a friend recently, and he said he was in law school on 9/11 at Yale, and they held class that day.
That is sad.
I was in New York City on 9/11. I was in school that day, and we came back, I think the next day. I think we came back the next day. So we always have stability. Come back to class. We will learn. Okay. Questions on your mind? Anything back from class? Anything in mind? Yeah.
How do you pronounce B-A-K-K-E?
Oh, Baki. Baki. Like Bach, like the composer. E. Baki. Not bake. Baki. And it's spelled with 2 L's, which is an odd spelling of the first name also. Alan Baki. Anything else? All right. I want to do a poll question. And the answer to the poll question is a lot less important of how you get there. Right? So I want to use this poll question to summarize how the tiers of scrutiny work with respect to the Equal Protection Clause. We sort of covered it last class, but I had to rush it more than I would have liked to. So here's the question, right? State A allows 16-year-olds to drive. Allows 16-year-olds to apply for a driver's license. State B allows 18-year-olds to apply for a driver's license. Does State B violate the Equal Protection Clause of the Constitution? Okay, the answer I think should be easy because I think I did it last week, but the harder part is how you get there. Because this is sort of analysis I'd like to ask for you on an exam or otherwise. Okay, another 10 seconds. Does anyone have it? A couple of you got it, or I'll just give it a few more moments and. All right, where am I? Oh boy, well, can I call on the invisible person? You were, Brooke, I know you were up last class. Sam, Sandra, you went yesterday?
So I guess it was coming, if it goes right here to them.
Did I do this side yet? All right, Marcus, you really want to go, so I'll call on you.
I mean, I think I kind of added some.
Okay, Marcus, I'll call on you because I think you really want to answer this question.
I would say no, unless someone from State A came to State B and wasn't allowed to drive at the age of.
But if that person, well, can you apply for a driver's license in a different state? You become a resident of that state, right? But that's the question, right? Can State A treat its own citizens in such a way, and State B treat its own citizens in a different way? What do you think?
Well, if that 16-year-old is in, no. So I would say no again, because if that 16-year-old is in State B, then they're subject to the laws of.
Okay, good. So they're subject to the laws. Right. So is it unconstitutional then, Marcus, to deny a 16-year-old a driver's license? Does that violate equal protection?
And if they come to State B?
Forget about moving. Doesn't matter. Let's say you lived in Texas your entire life, or you lived in New York your entire life, and then you try and get a license 16, the state tells you you can't do it. Is that unconstitutional? Why, tell me why not.
If the state has a reason or I'm trying to apply the terminology.
Good. That's what I want you to do. I want to apply terminology.
It means to an end.
Okay. So for Marcus, let's just start off. Actually, no, Sergio, let me go here, okay? Sergio, what kind of classification, right, do we have at issue, right? On what basis is the government classifying people? Okay, very good. So I'm going to start a little chart, which I think will help you, not a chart, but like a breakdown, right? So we have what's called a classification on the basis of age. Whoops. Okay. Oh, stop doing that, Google. Okay, there we go. Thank you. It does this auto jump thing and it drives me crazy. Okay. We have a classification on the basis of age. Now, Sergio, generally, when the government treats people differently based on the age, are we suspicious about that?
No.
Tell me why not.
Why
Well,
not?
so, for example, you drink when you're 21, you smoke when you're 18, you vote when you're 18. Maybe you have capacity to make a contract at 17. Maybe you can get married at 16 or with a parent 15, right? We have all these classifications in our society based on age. Is that suspiciously problematic about this?
It's usually not suspicious.
Tell me why.
I mean, usually suspicious would be something like race.
Oh, we'll get to race in a minute, I promise. But let's just stick with age for a minute right now. Why are we not suspicious about age-based classification, Sergio? You're correct, but just think it through because this is important. Why do age-based classifications not really bother us?
I guess because, I mean, like a child, there are certain things that a child cannot do.
Mm-hmm.
And
But right, exactly. So children generally lack capacity to contract, for example, right? But why they lack capacity to contract?
like mental capacity.
Yeah, kids are not as mature. I think we all okay saying that. Some of you maybe had kids. Some of you, all of you were kids at one point. I think at least children generally lack maturity. They might not be as I don't want to say smart because it's the wrong word, but they might not know as much, right, about the world works, right? They may lack responsibility. So the government treats people of different ages differently. Now, that's not based on some sort of, hatred of children, right? It's not based on some sort of animosity of little kids. It's based on a fairly simple fact of life. Younger people are less mature, and maybe the law gives them certain disabilities. They can't make contracts, etc. Right? So we have in the law a lot of classifications, and we call them non-suspect classifications. A non-suspect classification. Now, I just give you age as an example, but really anything can be a non-suspect classification, right? For example, income. Let's say the government adopts a policy that, predominantly classifies people based on their income. You have tax brackets, right? If you're at this level of income, you pay this much money. If you're at this level of income, you pay this much money, right? Maybe people don't like it. They think it's unfair. But the government can say, we want to treat people differently based on how much money they make because they can afford to pay more taxes. Yeah, nothing inherently problematic about this. So when you have these sort of non-suspicious or non-suspect classifications, we apply what's known as a rational basis scrutiny, right? Rational basis scrutiny. This is the most deferential form of review that we have in our case law, rational basis scrutiny. Okay? And Marcus mentioned this a moment ago. When we're talking about scrutiny, we have to compare the means and the ends, right? What is the government trying to do and what are they trying to accomplish? So in this case, the government says we want to limit driver's license to 18-year-olds, impose an age-based classification. Why? Keep our roads safer, right? Keep these irresponsible kids off the roads. Okay? Now, is it a good way of keeping our roads safe by keeping kids off the roads? Yeah, right? If you want to keep irresponsible kids off the roads, reducing the driver's license age or increasing it is a rational way of doing it. Now, is that the only way? No. For example, they can say, let's give a very difficult road test to 16-year-olds. If they pass it, give them their license. If they fail it, tell them to come back next year and maybe make the test a little bit easier. If they pass it, great. If not, come back when they're 18, give an easier road test, right? We could structure it with different difficulties of road tests, different ages, and if they pass it, they get their license. But we don't require the government to have such a precise solution, right? What we might call narrow tailoring. Think of a suit, right? If you buy suit at a custom tailor. They make it so it fits your body perfectly. It's narrowly tailored. It's exactly what you need to accomplish the goal. Or you buy a suit at, you know, Walmart, off the rack. It's going to hang off you. But it works. But it works, right? The rational basis test is like the Walmart suit. It doesn't have to fit you perfectly. Does not fit you perfectly, but you're not naked, right? You're clothed, right? It keeps you warm, right? That's how you think of rational basis review, okay? And I'll give you the test. We say that the government policy is rationally related to serve a legitimate governmental interest. By the way, you'll see this framed in 100 different ways in different books, whatever. Don't kill yourself in the exact framing. If you go with this, you'll be okay. But you're going to see it framed in slightly different fashions. So we have this sentence, right? The government policy is rationally related to serve a legitimate government interest. And let's think what we're doing, right? The government policy, that is your means. That is your age classification, right? That's what you're actually doing. You're limiting licenses to 18-year-olds. Okay? What are your ends? That's the legitimate government interest. That's your keeping highways safe. Okay? And then you have the fit between the means and the ends, which is a rational relationship. Right? There has to be a rational relationship between the means and the ends. That is, does it make sense to limit licenses to 18-year-olds to keep the road safe? Sure. Is that the only way of keeping the road safe? No. Is it the best way of keeping the road safe? Probably not. The road test approach might be a little bit more accurate. But because we have a non-suspect classification, we don't put the government to that sort of rigorous standard. Everyone with me so far? Marcus? I'm sorry? The fit was rational relationship. Right up there. Okay? That's how rational basis review works. The government doesn't need the perfect policy or even the best policy. It just has to be rational. And we'll discuss what rational means a little bit later. But it doesn't require a lot. Okay? Critically, with a rational basis review, the burden is on the challenger to show the law is irrational. Okay? The burden is on the challenger to show the law is irrational. What does that mean? The government doesn't need to put forward evidence to show why they need an 18-year-old driver's license, right? It's the job of the 18-year-old to put forward evidence to show why he needs a license. Or it's the job of the 16-year-old to put forward evidence why he needs a license, right? The burden's on the plaintiff or the challenger. Why is this important? Generally, in constitutional litigation, the party with the burden loses, right? It's a general rule. Any court you're in, if the court puts the burden on you, you're probably going to lose. In civil, at least. Criminal is a different story because the burden's always in the government. But in a civil litigation, if you got the burden, you're probably going to lose. Okay? Everyone with me? And one last thought. We've used this phrase in a few different classes before, but the rational basis test, as it's known, is akin to the presumption of constitutionality, where the court presumes the law is valid unless the plaintiff comes forward with evidence showing it's not valid. And it's got to be a lot of evidence, not just a little bit. It's got to be a very heavy load of evidence. The upshot of the rational basis test is the government wins, right? Generally, when you're arguing or fighting or litigating against a rational basis test, the government wins. And we did a case called Williamson v. Lee Optical. Remember that one with the eyeglasses? We did that case about a week or two ago. That's a special type of what's called rational basis review, where the court says, we don't even care if there's actual evidence. We can just make crap up, make up evidence, and that's enough to show a rational relationship. So as the rational basis test operates today under the Williamson v. Lee Optical test, it's basically impossible for the plaintiff to win. You're going to lose, right? Imagine going to court and making an argument, and you put your briefs in, right? And you give your argument, and you're all proud of yourself. And the case is submitted. And then a couple months later, the judge writes an opinion. He says, well, all of your evidence is good, but I'm going to come up with some other evidence, right? The judge puts forward evidence that's not in the record, saying, here's why you lose. It's moving goalposts. You can't win, right? It's very frustrating. Yeah.
I have 2 questions.
Please.
Was it Morrison where they talked about the rational basis? And they said that you had to at least give some reason why the law was constitutional?
Are you talking about Morrison v. Olson or United States v. Morrison?
United States v. Morrison.
That was the Commerce Clause case, right?
Wasn't that the Violence
Yeah.
Against Women Act?
So here's where you're going to hate me. The phrase rational basis means different things in different places. Let me explain this to you, please. But good question, Mia. You'll see the phrase rational basis in the Commerce Clause. You'll see it in the Equal Protection Clause. You'll see it in the Due Process Clause. You'll see it in the free speech context. You'll see it in the free exercise context. And in each context, Mia, they have different meanings. It's really annoying. Right? The exact same phrase, rational basis, has like 5 or 6 different contexts with different meanings. For example, rational basis in the free speech context is very different than rational basis in equal protection. They're not the same. So when you go through your notes, and I think someone asked me at rational basis when we did the Commerce Clause, like please don't ask me that now. I think I object, maybe it was last year, but I usually object. It was you? Yeah. Very astute. Don't treat the phrase rational basis in the Commerce Clause context in the same fashion as I'm giving you right here. This is for equal protection. Right? This test is only for equal protection. Yeah? We'll do another one, I guess, next week when you do due process. It's a different type of rational basis test.
The second question?
Yes, Mia.
With rational basis, does that mean then that it doesn't matter if it is like burdensome on one individual? It's the overall perspective of the law. Like,
I'm not sure what you mean.
like it seems like with strict scrutiny,
Mm-hmm.
like if it infringes on one individual's constitutional rights, and then they look at, of course, all the surrounding things, like if there's like the Korematsu kind of aspect of it, but like rational basis, it seems like if it infringes on one person's rights, but there's a rational basis for it, then it's
For class-wide. Yeah, okay. Now I think it's your question. If I don't get it, correct me. So with the rational basis test, even if the law might be inequitable for one person, the government can say we're operating in a big picture here, right? We're trying to deal with a very big problem, and the problem's not precise. And in some places, the solution might work well, and other places it might not work so well. Or they can say, we want to move incrementally, right? Where a problem has multiple stages. And we're only addressing stage 1 here, which might affect one person, and we'll get to stage 2 and 3 at some point in the future. They may never do it, right? So with rational basis, it's incrementalism, right? Solving a big problem, maybe one little piece at a time. So there's no requirement that it be narrowly tailored or that it might impact one person at a time. Does that get your question? Yeah. You'll see this phrase about You'll see this phrase about incrementalism a lot, right? The government acts incrementally, and Lee Optical discusses this, right? That there might be a problem that's multifaceted, and the government addresses only part of that problem here, and maybe they'll address part of the problem in some other statute which never gets enacted. Yeah, Mai.
Just piggyback on Mia's question, but another case is
Yeah.
the city of Bernie.
Yeah.
Is the test of a person's free exercise of religion can only be a substantial burden if the government's actions was necessary to achieve a compelling.
It sounds a lot like this, doesn't it? It's different.
Exactly.
It's very different. Yeah.
A different thing.
Yeah, unfortunately, you're giving the test for RFRA, which is the Religious Freedom Restoration Act, which discusses substantial burdens. So again, please, when you're giving me a test for the midterm or the exam, when you get to your final, when you're giving me a test, be very careful that you use the test from the clause you're talking about, right? So with the city of Bernie v. Florence, it's a different type of burden we're talking about. Just, you have to keep straight. I'm sorry, you're going to hate this, but just follow along, and I promise I'll guide you. Which is why I don't mention rational basis the first half of the semester. Will drive you bonkers. And when we do Korematsu, I think I mentioned strict scrutiny very briefly and say we'll come back to it later. I think I said something like that. The court isn't very creative. So when they have like a phrase like, oh, this is great, rational basis, let's apply this in 8 different ways or 6 different ways, whatever it happens to be. Okay, everyone with me so far? So that's the rational basis test. And again, go reread your notes on Williams v. Optical. That was actually an equal protection case. Okay, so this is number 1. I'm going to skip number 2 for now, and it'll be obvious in class next week why I'm skipping number 2. But then we have what's called a suspect classification. A suspect classification. A suspect classification. And the, classic example, or the most famous or most common example of a suspect classification is race. It's not the only one. Race is in there, religion's in there, national origin is in there. The list is a little fuzzy. Once you get beyond race, religion, national origin, it gets fuzzy. But race is the easiest one. It's the most discussed issue in all cases we have in our book. So I'll focus on race for now, right? When we have an age classification, we're not suspicious, right? Everyone eventually ages out of childhood, hopefully, God willing. Maybe not. Present comma excluded, right? We eventually all age out. Yeah, right? But race is a different classification, right? Race is what's called innate, I-N-N-A-T-E, right? In other words, it's immutable, another word, right? You don't change it. It's something you're born with. And we have a history in this country of racism. And it's because of that history that the courts are suspicious when the government classifies people based on their race. I knew you were going to say it. Don't, everyone always says that. Everyone always says that. He didn't change it, right? People are suspicious based on racial classifications. So therefore, the court developed what came to be known as strict scrutiny. Now, the phrase strict scrutiny wasn't actually used in Korematsu. I don't think it was. I think they called it the most rigorous scrutiny or something of that nature. But the phrase that came to be known as strict scrutiny. And I think the most easiest example to apply this in is not actually Brown. Brown doesn't use this phrase, but Loving, right? Loving, the mixed marriage case, right? And the court said that the purpose of the Virginia law was promotion of white supremacy. They said that clear as day, right? So they said this is such an illegitimate end, right? Such an illegitimate purpose that it doesn't matter what they're actually doing, right? When you start off with a goal of white supremacy and promoting it, it doesn't really matter what means you pick. But there are other cases where the court is a little bit more tolerant, perhaps, of racial classifications. And that's our subject for today, which is the affirmative action cases. So let me give you the test for strict scrutiny. Okay? The government policy is narrowly tailored to serve a compelling governmental interest. Right? Strict scrutiny. The government policy is narrowly tailored to serve a compelling governmental interest. Now let's use affirmative action as an example, right? What are the means? The use of race in admission to public institutions, whether it's the quota used in Bakke or the undergraduate policy in Michigan where they add points, or the holistic thing in the Michigan Law School, right? That is your means. It's some sort of classification where you're sorting people based on their race. Okay? What is the end, right? What is the goal? Now, the goal here, at least according to Justice Powell, as was discussed, are the educational benefits of diversity. It's not diversity by itself, merely having a mixed, class with different races. It's the benefits to education that derive from having people from different backgrounds in the classroom and on campus. So that's your means, that's your ends. Now, what's your fit? Narrow tailoring, right? Narrow tailoring. So I want you to compare the test for rational basis and the test for strict scrutiny, right? And just go one at a time. Okay? Here, the ends must merely be legitimate with rational basis. With strict scrutiny, the ends must be compelling, right? What's the difference between legitimate and compelling? Compelling is a hell of a lot more important, right? Legitimate means basically not stupid and not crazy, right? Basically anything can be legitimate. But compelling, at least as the word signifies, it's something really important, right? So, for example, Korematsu. What was their government interest there? National security, preserving the Union from sabotage, right? Putting aside whether the means were legit, whether the means were okay, I think everyone agrees that preventing the nation from sabotage is a compelling interest. How you get there, we can argue, but the basic gist is the end is compelling. Now focus on the fit. We have rational related, and we have narrowly tailored, right? Think back to your suits, right? You have the custom suit or the suit off the rack. Is this something that's going to be very precise, or something that's very whatever? When you have an affirmative action policy, is it using race in the least, I'm sorry, let me say the sentence again. With affirmative action, are you using race in the least necessary manner? Right? That is, are you using race only as one factor among any? Or are you using that as a sole factor that just blocks you off one seat at a time, like in Baki, right? That is the basis of our Equal Protection Clause jurisprudence, right? When you get to strict scrutiny, how heavily are you using race? Is it the only factor, like in Baki? Or is it one of many factors, like in Grutter? Or Fisher, perhaps, right? That's what I mean when I say rational related versus narrowly tailored. As you go down this list, right, the burden changes. With strict scrutiny, the burden is on the government. Right? The burden's on the government. Why is this important? Because the government must show why their affirmative action policy is valid. The government must show why their internment policy is valid. Right? It's not the job of the Alan Baki challenging the program to show why he should be admitted. Instead, the burden's on the government to show why he was excluded. Right? And again, generally with litigation and constitutional law, if you have the burden, you lose. Generally. Affirmative action cases don't approve the rule, because there the court upheld some, but not all the policies at issue. And to the extent that we have a presumption, you might call it the opposite, the presumption of liberty, right? That the plaintiff, the challenger, prevails, that you presume a race-based classification is invalid unless the government can show it's justified. There's a good enough reason for it. So there's like a symmetry, right, between rational basis and strict scrutiny. They're like a mirror image of each other. Everything's opposite. As you go through your studies, it's not enough to merely just memorize these two paragraphs. It won't help you at all. I promise you it won't help you at all. In the exam, not a lick. You have to understand what I just told you. So this last 30 minutes, we're 30 minutes in, you need to be able to understand what I just told you and like spit that back out and get it. Because if I ask you to go back to your question of the day, right? Let's go back to our question for the day. And by the way, the answer is false for this one. Hopefully, most people got that one right. Very good, almost everyone. But if I ask you, does state B violate the Equal Protection Clause, here's what your answer looks like. First, we have an age-based classification. That's not suspect. Second, therefore, rational basis review applies. Third, what are the means? An age-based classification. What are the ends? Highway safety. Are they rational related? Yes, they are. Therefore, the challenger hasn't met his burden. The law is valid. Watch this again later, right? But what I'm trying to tell you is, if you just say, this is why I don't give multiple choice exams. If I just give you B, no, I'll be like, okay, that's easy. But you have to actually understand why a relation between the means and the ends fit. Most law students never get this. It's actually very sad. I didn't get it when I was in law school until many years later. People don't get what means. The end justify the means. No one knows what that actually means or what that signifies. Anyway, if there's a race classification, you ask if, okay, we have number one, we have a suspect classification. Number two, therefore, you apply strict scrutiny. Number three, you can say that this holistic affirmative action program is narrowly tailored, only uses race in a small fashion. Therefore, it's valid under strict scrutiny. You get the gist. But you need to walk through this one step at a time. Race was used in a small factor, for example, in the holistic approach, as one of many factors, right? I deliberately skipped number 2 because I'm going to do this next class, but it's sex. And I'm going to skip it here and just say it's a quasi-suspect classification. That's subject to intermediate scrutiny. I'm not going to go through this, but just for your notes to be complete. The government policy, the means, is substantially related. That's the fit to serve an important governmental interest. Those are the ends. And the burden is on the government. The court has applied different approaches to scrutiny for sex, which we'll cover next class in great length, but that's the general gist. And just compare 2 and 3, right? Compelling interest, important interest, right? Well, if you're ranking them, importance here and compelling is like up here, right? So it takes more to classify in race than it does to classify on sex. Presumptions, there might be some valid reasons why sex-based classifications are permissible, whereas they're not the same for race. Now, the reason why I'm going to soft pedal this a bit is there's a case you're reading on Wednesday called United States v. Virginia, the VMI case. As it stands now, there's not much of a difference between strict and intermediate. I think they're different in name only. The way the court applies intermediate scrutiny is really similar to strict scrutiny. So, there's not much of a difference. But who knows? Maybe there will be a difference in the future. I don't know. But the labels are different, but the analytics are basically the same. Okay? Okay, everyone with me? Okay, and this is only for your notes, and this responds to Mia's question a few minutes ago. The first 3, these are all for equal protection. I'm going to give you the standards for due process, but I'm not going to teach you. I'll just, for your own notes to be complete. With due process, we don't classify people based on who they are. Instead, we classify the type of right at issue. So we have 3 types of rights. Non-fundamental rights and fundamental, I skipped 2 on purpose. Non-fundamental rights and fundamental rights. This goes back to Caroline Products in footnote 4, which we covered, right? Certain types of rights are deemed very important. They're called fundamental rights. Other types of rights are deemed not so important. They're deemed non-fundamental rights. We give non-fundamental rights rational basis scrutiny, and I'm not going to give you the test, but just so you have for your notes. And then we give fundamental rights get strict scrutiny. So the exact same phrase, rational basis and strict scrutiny, can be used in equal protection and in due process. Right? There's a liberty that's fundamental or not. Now, why did I skip number 2? Abortion. It's in a category unto itself. It doesn't fit anywhere else. And we apply something called the undue burden standard. And we'll cover this at great length when we do abortion cases. So it's not called intermediate scrutiny. Wouldn't that be easy, right? Wouldn't that be really easy, but it's called something else. So you need to memorize all these different tests in their different contexts. But go back later and you can look at this list for all of your notes to keep your notes consistent. But you need to internalize how to apply these different frameworks. Yeah, sorry, one time. Who's first? I don't know who's first.
If that's due process for both 14 and 15.
Oh, very good question. Very good question. Yes, she's correct. The court applies the same frameworks for the 5th and the 14th Amendments, right? So this is due process for the 5th and the 14th. Okay. And this is equal protection for the 14th and the 5th. That's Bowling v. Sharp, right, guys? Right? The court's basically said, even though the 5th Amendment lacks an equal protection clause, we're going to pretend it did.
Okay.
Yeah? Yeah, the Equal Protection Clause has no Fifth Amendment. We often call it the Equal Protection component, or Justice Kennedy calls it the Equal Protection principle of the Fifth Amendment. It's a product of the court's doctrine. I mean, if you look in the Fifth Amendment, I have it in my pocket all the time. It's not there, but the court acts as if it were there, which is what you need to know. Yeah, I'm just looking right there, Fifth Amendment. Nope, not there, still not there. Keep popping up, never appears. One of these days, it'll appear, but hasn't appeared yet. The penumbra is never, actually, so remember those solar eclipse last year? I actually went to Nebraska, which was in the, I forgot the name of the place, but basically where there's a full eclipse of the sun, and I wanted to go see the penumbras, the emanations. They weren't there. Unfortunately, it was cloudy. I was so angry. I flew to Beatrice, Nebraska, which is about, anyone know where that is? It's about 200 miles from Omaha. Just to give you a sense of where it is. I'm sorry?
I'm not very good at geography.
Me neither. But I basically found where was the closest place to a place United flies direct to that can get a cheap ticket, and it was Beatrice, Nebraska. So we flew there in the morning, and it was like very cloudy, and basically I missed the entire damn thing. It was cloudy. I was really upset. That's why I didn't see the penumbras. And then the worst part is basically 100,000 people were slamming this like 2-lane highway to get out, and I almost missed my flight. But I got home, got back to class for the next day, but no penumbras, no emanations. By the way, for the Griswold animation video, we're actually going to animate the Earth and the Moon and the Sun. It's going to be shadows. It's going to be very cool. Not that you'll see it. It'll be very cool. I'm sorry. Yeah, for the videos. Yeah, Mai, please.
To look up the list of fundamental.
God, just one at a time, please. One at a time. Thank you. Go ahead, Mai.
For the list of fundamental rights, we will get that from the Civil Rights Act of 1866.
Wouldn't that be nice? I wish that were the case, but no. The court determines what rights fundamental based on footnote 4 of Caroline Products, more or less. It's some of an arbitrary process. I wish it was the Civil Rights Act of 66. We should talk more about it. It's a very good law, but it doesn't really play a role. All right, so are there any questions on this framework? Yeah, Mia and Sergio?
So the strict scrutiny and the rational basis test for due process are different than the equal protection.
Yep.
Okay. What was Korematsu?
So Korematsu, we would characterize it today as a strict scrutiny case in equal protection because you have a race-based classification, right? Remember the sign saying all people of Japanese descent come to this location. The phrase strict scrutiny didn't really exist yet. The court only developed standards review later. So the court would often cite Hirabayashi as an example of strict scrutiny, even though Hirabayashi didn't actually apply it by itself. Does that answer your question?
Yes, thank you.
Yes, Sergio?
So just to, back to Mia's question, the non-fundamental rights, you said it comes from the footnote 4?
Basically, yeah. The entire idea that certain rights are more important than others.
For due process.
For due process, yeah. Yeah, footnote, it's so hard to teach you cases in the correct sequence because there's no good place to ever put it, right? Because I can do Caroline Products now, but it really fit in with the New Deal stuff. Or I could do the optical now, but really fit in with the New Deal Lochner stuff. So these cases, they sort of reinforce each other. You have to keep in mind, the court decides cases chronologically, not by topic, right? These are cases decided over the course of decades and decades. The first edition of Randy's book, which I wasn't on, was actually sorted chronologically, straight up chronologically, no topics, and it was a disaster. I actually didn't pick it for that reason, because it'd be too hard to teach. But if I had like 6 hours of ConLaw straight, I think I could pull it off. But we have to jump around way too much for it to make sense. But yeah, it's not done sequentially. Yeah, Mia?
The holding on falling B sharp,
Yeah.
it did say, though, that it was a due process case, though, right?
Yeah, the argument is that the Due Process Clause embraces the Equal Protection Clause of the 14th Amendment. Why, your guess is as good as mine. They don't really explain that. I mean, it's not nuts to think that the framers of the 14th Amendment didn't trust the southern states and wanted to put them under a tighter leash than they put themselves under. That's not a crazy conclusion, but the courts rejected that one. I think it's actually a plausible conclusion. All right, the federal government didn't do that much. Wasn't a reason why to put them under the same obligation, but it's not crazy. Okay. Anything else? All right, let's actually do our stuff for today then. Okay, so in our in class last week, we discussed the desegregation cases. And the desegregation cases are generally understood to stand for the principle that race should not be used as a classification for the admission of schools, right? Topeka can't send the black children in one place and the white children in another place. Everyone, I think, pretty much agrees that that's correct. But then we get to today's lecture, right, which is affirmative action. And here, there's a very sharp divide on the use of race. And there's one metaphor, which I think Justice Stevens puts in an opinion called Adirond, which I think is useful. Is there a difference between using race as a welcome mat versus a no trespassing sign, right? That is, are you using race to usher in, to embrace people of certain races for certain educational experiences, or are you using it to exclude those minority groups from certain educational experiences? And the court vigorously disagrees with this. Now, the basis of affirmative action, right, the phrase itself, people don't really know the history, which is why we put that little bit in your book. In the 1960s, and this is after Brown, as the federal government was starting to ramp up desegregation, President Kennedy signed a very important executive order, 10925. And it said it's not enough to simply have equal employment practices, that you just don't discriminate, but you take affirmative action, that is positive steps, to ensure that people are treated equally during employment without regard to their race. And this became a very controversial topic in the 70s as colleges began experimenting with different types of race-based admission policies, right? So Bakke was the court's first major decision on race-based affirmative action. If you couldn't tell, they couldn't really make up their minds. And the case was very fragmented. In fact, there was another case decided about a year before, and it also involved affirmative action. The court tossed it away because it said, oh, well, he graduated, so this case is no longer relevant, right? And because he graduated, we have to decide it. The court was very much divided on how to approach this issue. And the reason why should be, I think, should flow from the strict scrutiny test, right? We had just spent the better part of the 1960s applying strict scrutiny in a very strict fashion that basically said all racial classifications are presumptively invalid. And there's a phrase that you might see, strict in theory, fatal in fact. And this was published in a very famous law review article. Strict in theory, fatal in fact. In other words, if you have a racial classification, you're going to lose. So we have this history of the court saying no racial classifications, no racial classifications. But then you get to affirmative action, and the optics change a little bit. Why? Because these are policies designed not to harm the minority students, but to provide them with certain opportunities they may not otherwise have. Which brings us to Bakke, right? All right, who's up next? Aniqua.
I was next. I
Good.
didn't know what happened before I got here to class.
That's all right. You want to give me the facts on Bakke, please?
Sure. This was a case to challenge the special admissions program of a medical school in California. Basically, there was a quota for the admittance of 8 minorities per class of 50 mandatory admittance, and then it was doubled if the admitting class was 100, 16 per the 100, and there was normally a cutoff to deny applicants if their undergrad GPA was less than 2.5, but there's a special admissions committee for people who identify themselves as a minority or disadvantaged when their applications were completed, and then those would be forwarded to the special committee, and they didn't have to meet that 2.5 cutoff.
Very good. Thank you, Aniqua. So here we have what's often called a quota or a set-aside. You'll see it described in both fashions, right? where you have X number of seats in the class, whether it is 16, that are set aside for people of a certain race. Okay? Now, before we get to the facts, who's next? Adrian or Dusty? Who's next? Okay, Adrian. Now, I want you to compare the UC Davis admission policy to the one at Harvard that Justice Powell talks about.
Okay, so he stated that the Harvard one was an example because he felt that the admissions on race, let's see if I can find it, we could satisfy the strict scrutiny because it was promoting the educational diversity, that it wasn't about that. As long you could use race as long as it was about the promotion of educational.
Well, those are the ends, right? You give me half the equation, which is why it's important to understand this framework, right? Both, I think they were both achieving a certain end, right? They're both trying to get whatever benefits derived from a diverse classroom, right? But what was different between the UC Davis approach and the Harvard approach? That's the important question.
So I think Harvard said they didn't have a certain number, a certain quota they were trying to
Good.
get to. Whereas UC Davis had certain numbers that
Very
they were
good.
trying to satisfy.
Perfect, perfect, exactly right. Very good.
that word?
Exactly what I was looking for, thank you. That's correct. Okay, so both UC Davis and Harvard were trying to achieve certain interests, right? They were both trying to achieve a more diverse classroom in order to get certain educational benefits. And we'll get to those benefits after we do the Grutter case next, but I'll just leave it here for now, right? They were both trying to achieve certain educational benefits. Those are the ends. But the means were different, and the tailoring was different, right? What did Davis do? They said, we're going to have a racial classification with these 16 seats set aside. The court said, or actually Justice Powell said, I'll get to the breakdown in a minute, but Justice Powell said that's not narrowly tailored. It uses race as a huge function of the admission process. So think of like a pizza pie, right? It's almost 90% say of whether you get in or not, right? Pizza, yeah. It's a huge percent, see I did that, right? It's a huge percentage of your admission package if race is being used. Whereas with Harvard, maybe it's not 90, maybe it's 10%, maybe it's 20%, you don't really know. But it's more narrowly tailored. So again, compare the means and the tailoring. They both have the same ends. Justice Powell says that here the means are sufficiently tailored at Harvard, but the means are not sufficiently tailored at California, Davis. Therefore, he basically says, I find that the Davis policy is invalid, but the Harvard policy might be okay. Notice the Harvard policy, one second, the Harvard policy wasn't even at issue, right? No one challenged Harvard in this case. He was saying, well, you can't do this, but you can do maybe that. Yes, Monique?
I guess I didn't really understand the logic in this because it doesn't, I don't understand if race was just, or the Harvard plan, if it was just used as a factor in some schools, where's the accountability in that? Like how can you check and make sure that, okay, the ends of diversity is actually being met if you're still allowed to just use it as a factor and somehow just come up with not still a minority of students being admitted into these schools? So where's the accountability and factor?
So I'm going to jump ahead a bit, but I want to answer a question, right? So it's okay. So we have a concept called critical mass, right? In Bakke, Justice Powell said you can't have a quota. Then 25 years later, you have Justice O'Connor in the Grutter case that says you can use race to achieve a critical mass of diversity. Now, Monique will use a good word, I think, accountability, right? How do you measure how diverse a class is? Is there some way to check that? And there's a tension here, right? If you had a certain number of seats, say 100, and then X number of people for minority students, you can measure that pretty easily, right? But you can't have a straight-up quota. But UT Austin says we want to keep using so we get a critical mass of minority students. But they will not ever tell you what that mass is. They went to the Supreme Court twice, and their lawyer dodged and bobbed and weaved Would not give that number. Why? Because the second he gives a number, it's a quota. Right? He will not give that number because the second he gives a number, it's a quota. He can't do it. So instead, they use this phrase, critical mass. Now, to Monique's point, how are you checking if they're actually admitting enough? Well, you can then basically see, perhaps comparing the admission statistics to the statistics of the state they live in, see if it matches demographic numbers, might be one measure. But you can't, if they don't have a goal, it's hard to see if they actually met the goal, which is why they keep it very nebulous to find. Does that answer your question a little bit?
Kind of.
Good. Okay, good. We'll come back to Slade, we do Fisher, I promise. If we don't, just you can raise your hand again, okay?
Okay.
So Justice Powell, again, finds that race can be used as one of many factors that's narrowly tailored to achieve the certain benefits from diversity on campus. Now,
Let me ask you a question.
yeah.
Okay, so subjective. The whole thing is so subjective because, all right, so when the Harvard, when he gave Harvard as the example, and then so he says, as Harvard's admission program as one example of how race properly, in my opinion, may be taken into account. But we're talking about what's constitutional. So, in my opinion, is so.
We're in class, was this 19 or 20? There's not hard and fast rules here, right? Keep in mind, and I'll just make this point bluntly, there were 4 votes to strike down all affirmative action. Justice Powell was the swing vote, the moderate, the Kennedy of his day, if you will. But for his vote, the court would have 5 votes to declare all affirmative action unconstitutional. And not just unconstitutional, a violation of the statute, Title VI, which is a relevant provision, which says that schools that take federal money can't have racial discrimination. So, yeah, I mean, Justice Powell's opinion is very mushy, subjective, maybe to use your word. I think the alternative would have been a very different outcome for affirmative action if he said, you know what, I don't know the answer, so I can either just defer to the policy, which is what O'Connor, I think, does, or I don't know, but I'm going to say that the Constitution can't have any racial classification, strict scrutiny, I'll strike it down, right? So this case could have easily come out the other way, and he said, we apply strict scrutiny, these means are not narrowly tailored enough, I don't care about Harvard, it wasn't an issue here, it's unconstitutional, and then go figure it out. That could have just easily happened, 5 votes. Powell was, again, a swing vote. And let me make this point more broadly. Why am I talking about Powell? How is it possible that there are 4 votes to say that all of this is unconstitutional, 4 votes to say that this is fine, and then one guy in the middle who's really not sure, right? Why am I talking about one justice, there's 4 and 4?
Because of the Marx rule.
The Marx rule. Oh, what a beautiful answer. What's the Marx rule?
It's from a case decided in 1977. The key holding is when a fragmented court decides a case and no single rationale enjoys the assent of 5 justices, the holding of the court may be viewed on the position taken by those members who concurred in the judgment on the narrowest grounds.
Beautiful answer. Yeah, there's this rule called the Marx rule, which is a disaster to apply. But it says when you have a 4-1-4 split, it's a disaster. Don't even get me into these logic games, right? When you have a 4-1-4 split, you take for controlling opinion whatever is most narrow opinion. So again, you have 4 saying that this is all good, 4 saying it's all bad, and 1 saying meh. So the meh is now the controlling opinion. But what exactly did Powell even hold? He said, I find unconstitutional the program before me, but this other policy, which wasn't even in the case, might be okay. Might be okay. He didn't say it was, he said it might be okay. So for a quarter century after Bakke, there was a lot of uncertainty, right? A lot of uncertainty. In fact, the Fifth Circuit here in Texas struck down UT's admission policy in a case called Hopwood, which you probably have read about, in the Fisher case. And they said it's unconstitutional. Now that changed in Grutter, but there was a period of a quarter century where things were largely uncertain. Okay? So are there any questions on Justice Powell's opinion in the Bakke case? On Justice Powell's opinion. Yeah, Mia?
The classifications, the two-class theory?
Yeah.
Was that the white majority against the black minority?
Yeah. I think Justice Powell was trying to go towards the Harlan Colorblind approach. We don't want to have 2 classes. But let me actually build on Harlan for a minute, right? We don't have the other opinions in your book. I nudge Randy, but the case is already too long. But Justice Marshall has a dissent that I actually find a lot more persuasive, at least in part, than Justice Powell. Now, when most of you thought about affirmative action, at least with respect to African Americans, you probably thought this is there to make up for centuries of discrimination and oppression. Centuries, not years, centuries. And if you read the LBJ speech, right, at Howard, he says, you can't take someone, break their knees, and put them at the starting line. You have to give them a little bit of a head start. When I first studied this, like, wait a minute, that seems a hell of a lot more persuasive as justification than diversity benefits in education. Everyone I said to, yeah, of course, right? That's why you have affirmative action, for African Americans in particular. The court rejects that. And Justice Powell says, we're not going to have the two-class creditor, the debtor-creditor race. Always mess it up, right? So the entire basis on which affirmative action stands in the minds of most Americans as making up for past oppression and current day oppression is not the basis the court actually finds valid. Instead, the basis the court finds valid is something very technocratic, right? That if you have the right mix of racial balance in your classroom, you get certain benefits from learning, which is, I'm sure is true. Not arguing with it at all. It's not my position. But it doesn't seem the interest to be as compelling, right? This is Thomas's point in the Grutter case. If we take compelling to mean compelling, educational benefits are not it. It's important maybe, definitely legitimate, but is it compelling? So the reason why the Powell opinion is so important is it sort of forks out strict scrutiny, right? That if we study strict scrutiny, affirmative action doesn't really fit into it. It's almost like its own sidecar, if you will. Because if you apply strict scrutiny, this is an easy case. So instead, they either water down strict scrutiny, which I don't think they do, or they sort of fork it off the road by making exceptions of what's compelling or not. So as you study cases involving racial classifications, the courts always starts flipping things around a little bit on the scrutiny side when we talk to race-based preferences. Now this happens not just in education. We also have a case called Adirondack versus Pena, which is in your book. I don't assign it, which concerns race-based preferences for government contracts. That if you have a minority-owned business and they want to get advantages for government contracts, are those valid? There were a lot of cases in that in the 80s and 90s. Those cases have somewhat fallen away. We don't get those many anymore. All right. So any other questions on Bakke? Questions on Bakke. Very important case. It'll become obvious why it's important when we do O'Connor. Yeah, Clay.
Repeat Mark's rule, please, when you have the 414.
Yeah. Tim said it for me better than I could say it. But the Marx rule simply states that when you have a 4-1-4 split, the controlling opinion is the most narrow opinion. But let me tell you, it's hard to apply. And lawyers and law professors argue about this all the time. It's not a clear rule, the Marx rule. It's not a rule. It drives people nuts. Right? If the court can't cobble together a 5-member majority, we're just guessing at that point. And it's very frustrating. It's hard enough with the holding of a case when they have 5. Now imagine when there's not 5. And sometimes you have 3-2, 1-3, like really bizarre splits. That might be 10. But you have sometimes really bizarre, I can't count. But you have these really bizarre splits sometimes, which drive me nuts. Yes?
So you said that you don't find many cases anymore about when businesses.
At the Supreme Court, at least.
Okay. Do you think that that's because there are requirements now that, especially for the government, that you have to have a certain, when you have a certain dollar value, large companies have to have certain percentages that they must meet for minority-owned businesses? That would possibly explain why, because now there's laws that have been put into place.
Well, the question is, are those laws constitutional?
Well, they're in effect. Most of the
I know they're in effect.
Not constitutional, so.
Yeah, no, I know these laws are in effect. This was a huge topic in the 80s and the 90s, and it's just largely fallen off. But so I don't quite know why. I don't know all these laws are valid, but they're not.
They're valid because they're in effect.
Oh, I know they're in effect.
They're constitutional or not. That could be a reason why those cases, you don't really.
Let me put it this way. The challenges to those sorts of laws have fallen off. I don't know that the laws changed. They're not challenged as much as they used to be. Yeah, I don't know why. Yeah, Mia.
One thing that Powell said was that basically that nobody is entitled to greater protection in terms of equal protection. There are words of the clause. was for the police.
Yeah. I mean, it's so. Let me answer the question this way, right? If you adopt the Justice Marshall dissent of saying that this is designed to make up for past oppression, the consequence of that is O'Connor's 25-year clock. That at some point that justification runs out.
Is it because this is a positive?
And one other time, the other consequence of that approach is that not all minorities can have the same claim to affirmative action, right? Where some groups perhaps have bigger or lesser claims. So I think, or they become majorities. Yeah. So I think Powell is also recognizing that if we start picking and choosing based on level of oppression, that it's not as easy to justify it for all different types of groups.
Does that approach extend to other applications of equal protection?
What do you mean?
Or is it just in affirmative action where there's like positive?
Well, again, the court has never said that certain types of racial classifications are worse than other types. Just all racial classifications are bad. In fact, I'll give a second, Kenesha. Right now, there's a trial going on for Harvard. You may have been reading about this in the news. At this very week, there's been a challenge to Harvard. It's like, wait a minute, Harvard's private. Why are they? It's not 14th Amendment. It's Title VI, which limits funding to schools that accept federal money. And the argument is that Harvard's admission policy discriminates against Asians. 6.
Isn't that Ed Bloom? Doesn't he like seek a lot of
Yeah. Ed Bloom, the same guy who brought the Fisher case, he's actually in your book next to Abby Fisher. That's him. So the same guy who brought the Fisher case brought the Harvard case, and they've argued that Harvard basically has an anti-Asian quota. So the effect of that is that basically Asians are being excluded. And now Harvard's on trial about this. This has gone on for a while. So if your position is we're doing this based on past oppression, then it gets harder when you do race by race. Whereas educational benefits from diversity is somewhat open-ended. Yeah, patient.
That's kind of what I was going to say is how do you say that you're doing something based on past oppression when I'm not sure how you put a 25-year clock on something that lasted for hundreds of years. That's not a reparation, if you will. And secondly, the whole affirmative action thing is interesting to me because not all minorities need that. Many minorities are in the top 10% or 5%, like the girl in the other case AUT was, she was in the top 10% of her class. And so everybody does it, the box always, it's just interesting to me that the only way that people of certain races and ethnicities can get into universities or have jobs or things is because of affirmative action, which really is true. So if you want to do something about it, or if you want to make it an equal playing field, you do things like when I did recruiting in universities, I told them to send me the resumes. I wanted nameless resumes. And then you just pick based on the qualifications, as opposed to putting somebody in a box based on their color. I've never quite really understood how that erases anything, especially when you say you're going to put a clock on it.
Yeah.
You can't erase hundreds of years of something in 20 years.
I agree. By the way, Justice O'Connor's 25-year clock was not meant to be taken seriously. And let me segue to Grutter. When Fisher was argued, I think Justice Scalia made a crack saying, we're like 19 years from Fisher. He said, are we 25 years yet? And then I think the lawyer said that does, So the 25-year clock was, I think, a very poor choice of words. She was trying to make a rhetorical point that I think fell real flat. I don't know why she did that. By the way, Justice O'Connor is, I think, 88, and just today it was announced that her health is failing, and she's more or less pulling back from public activity. So she's not doing too well health-wise. Very sad. She's a wonderful person, very kind, very smart. I've met her a couple times, but she's not doing well. So we'll think of her today. It was not a wise thing to put in that opinion. I don't think anyone thinks that was a good idea. All right. Anything else on Baki before we move on to Grutter and Gratz?
I have a general question.
Yeah.
If this wasn't in, if affirmative action wasn't in place, or was this Michigan? No, California.
California.
Would it have eventually changed? You know what I'm saying? Like, I mean, if they hadn't implemented this to take affirmative steps to enroll a diverse student body, how would they have gotten a student, a diverse student body?
I'm sorry?
GPAs.
So let me answer the question. California, guys, just one at a time. One at a time, please. So California in the 1990s actually enacted a proposition called Prop 209, which prohibited the use of race in education. Still in effect today. So as it stands now, California schools can't use race. And a common criticism is that they are having difficulty of achieving the sort of diversity they want because they can't use race. Now, I think they do in just in different ways, and there's been a lot of litigation about this, but they can't do it overtly.
Well, I'm just curious, okay, because for this, I don't remember. I'm trying to remember. This is the first case. I can't remember. They didn't talk about federal funding in this case, right? No.
Well, not in your excerpt.
Okay.
In the full case that's not edited, they do discuss. Yeah, so 4 justices found that it violates Title VI to have any racial classifications.
Okay.
And that's the issue in the Harvard case when I mentioned a moment ago. Harvard's not about the 14th Amendment, it's about Title VI.
Okay, I was just wondering because in all the cases we've studied, most of the cases we've studied, the conservative justices have been all for, state rights and state sovereignty and state own, states own, running of their own government, basically. And you don't hear that here. So and I didn't see the Title VI part in here. And so I was just wondering, that it's okay for the Supreme Court here to sort of kind of reach into the state.
Yeah, I mean, the federal power over funding led to widespread desegregation.
Okay, so
yeah.
So that part is
okay. Anything else on Bakke before we move on to the Michigan cases? Okay, who's next? Samantha, I think you're next? Yes. All right. So Samantha, let's just try and consolidate this a bit. Can you explain to me how the Michigan law school admission policy differed from the Michigan undergraduate policy, please?
So the undergraduate policy assigned points to applicants.
Okay.
There was a maximum of 150 points, but students that were in a underrepresented racial or ethnic minority group automatically got 20 points. For the law school, they didn't have...
Guys, just one at a time. Yeah, sorry.
The law school policy, they focused on...
Oh, sorry. I'm sorry. I thought you were whispering back to them. I didn't see you were getting pizza. I'm sorry. I apologize. No, I apologize. I thought they were having a side conversation. I'm sorry. It's yummy pizza. I'm sorry, Samantha. I didn't mean to interrupt you. Go ahead.
The law school's policy, they basically said that they were focusing on academic ability. There was no point system.
Okay.
They said that they were focusing on academic ability as well as looking for applicants that could contribute to a diverse student body and that they could contribute to the learning of those around them. So while they didn't define the diversity factors they were looking for, they've had a long-standing policy of looking at racial and ethnic backgrounds as far as the diversity factor that they were looking for.
Okay, very good. Thank you, Samantha. So we have the Michigan case, right? And it seems there's always pairs, right? In Bakke, you had the California one and the Harvard one. And in Michigan, you have the undergraduate one and the law school one. And here we have the majority opinion by Justice Sandra Day O'Connor, who I mentioned a moment ago. And she was, for her time, the so-called swing justice, the justice in the middle. She did much the same that Justice Powell did in her time in the court. Generally conservative, but on certain social issues, abortion, affirmative action, she somehow found herself in the middle. So the court splits it. The court finds that the undergraduate policy was unconstitutional, and they found that the law school policy was valid. And I think Samantha gave a very good explanation of why. We talk about the means and the amount of tailoring, right? That's what we ask ourselves. The undergraduate had a fairly rigid formula. It wasn't a quota. It wasn't a set-aside. But it mechanically added a number of points based on an applicant's race. So having a perfect SAT score was in some cases worth less than having a certain race in your application box. Okay? And the court said that's too mechanical, right? That's not narrowly tailored enough, right? There's not sufficient tailoring with the undergraduate use of race. The law school, however, is different. The law school has what they call a holistic approach. Holistic approach. Elliot, help me out here. What does that mean for the law school to have a holistic approach? I don't know what that means. I know what it means, but being rhetorical. What does that mean, holistic? What's that? What exactly does that signify?
Holistic,
Yeah, exactly. What does that mean? She uses that word in her opinion all the time. Yeah.
I'm not seeing it, Professor. I don't know.
Maya, what does that mean?
I would think it means comprehensive.
Okay, give me an example, right? What does that mean, comprehensive?
It means you check a totality of everything together, when race is like a factor of a factor of a factor.
Oh, that's the phrase. Thank you so much. Yeah. So Justice O'Connor says the Michigan Law School uses race as a factor among other factors. A factor of a factor of a factor of a factor, right? Many factors. So it's not just being a certain race gets you X points on a grid, right? It's race is used holistically as one of many factors. But, Tim, my question again is, how exactly is race then used, right? To go back to Monique's point a few minutes ago, with a formula, you know exactly how it's being used. You can measure results, right? Use your phrase. But with holistic, what the heck does that even mean, right? These are not robots assigning admissions. These are human beings, right? You have human beings working in an admissions office. What exactly are they doing?
In this, they really don't clarify.
Ah. I'm sorry, Adrian?
I believe they were doing something similar, they just didn't say it.
Oh, say it louder so everyone can.
There's no way that you're able to use something as a factor because you have to determine what weight that.
Oh, what a good answer. What a good answer. Thank you. So hear what you said, right? To have a factor, you have to give that factor a weight. How is that factor weighted, which was kind of asking this row, which I think Adrian got to it, right? They're playing, right? Which is why this Harvard trial is so significant. Justice O'Connor makes a very big point. She says, we will defer to the manner in which they use their policy, right? Generally, with strict scrutiny, it's not deferential. We just defined this a few minutes ago, right? We presume that things are unconstitutional. But in Grutter and in Fisher, right, the court says there's an important deference to educational institutions. We are not going to scrutinize, we're not going to second guess how they are doing their business. Now, Adrian comes and says, they're doing the same thing, just not telling you about it, right? They might not use a grid. They might not use points. So Justice Ginsburg, right, wrote a concurring opinion. Is in your book or not? I can never remember. Okay, I'm sorry. Do you have the Ginsburg and Fisher? You have the Ginsburg and Fisher, right? I can never remember. Anyway. But she wrote a concurring opinion in Grutter also. So let me give you I'll just summarize it. Ginsburg says basically what Adrian says, right? Let's not be fooling ourselves here. No matter what the school calls it, they're using some sort of formula. Oh, yeah, thank you so much. It's in Gratz, I couldn't remember. Yeah, thank you, Brooke. Right, Ginsburg says, let's not be kidding ourselves, right? The school is going to do what they're going to do here. Don't make them go through all these steps of making all these justifications. Let's just defer to them altogether. And I think there's a candor to that that's appropriate, right? I think the majority in O'Connor is basically pretending that the policy is something that's not. And the lawyers are all too happy to pretend that it's something it's not. And think of the Fisher case for a minute. I'll jump ahead briefly. You have the 10% plan, right? The Texas top 10, it's like 7 or 8, but you have the Texas top 10% plan, right? it was designed based on the fact that Texas high schools are racially segregated in different jurisdictions. That's how it's designed. In fact, a professor at UH, Michael Olivas, he teaches across the 45, he designed it saying, look, I know what the racial breakdown is of Texas high schools. He can mathematically count it. And if we have the 10% this high school, and 10% this high school, and 10% this high school, we'll have a more or less, not perfectly, but a more or less diverse class of a certain basis at UT. So there's a certain suspension of disbelief with these affirmative action cases where they say, well, we're going to defer to their judgment when they know full well what's going on is basically formulous, mechanical of some sort, which again is why the Harvard case is significant. Harvard claimed that its affirmative action policies were trade secrets. You know what that is? Like the formula to Coca-Cola, right? Yeah, that it's locked away in a vault somewhere and they can't tell you what it is. But the court demanded that Harvard open up their books. And you now have a trial where the admission directors are being cross-examined. And let me tell you, the record in this case is going to be very significant. Because Harvard's the best university in the country, right? One second, I'll get you in a second, I promise. And Harvard's going to explain how they're using race. And they can't wiggle away saying, well, we just want this critical mass. They have to give numbers. And they actually have to reveal people who are admitted and people who were denied on various bases. Now, the irony is, Justice Powell said Harvard's good, right? And then maybe, no, they actually aren't when you look at through under the curtains. Yeah, Adrian, go ahead.
A couple of points with that. I can see where Harvard is saying that they're trade secrets because their formula seems to work.
Ah.
So they are successful. Their matriculation rate is extremely high. They're diverse. They get them in and they get them out, and they're successful. So I can see that argument. But my second point is this. If you look at race and you align it with socioeconomics, and you say, okay, I have this formula, because a lot of Ivy League schools, that's what they do. They tell you, I'm looking at the whole student, right? I'm just not looking at one thing because we want to know what you're going to bring to our school, to the whole body. So if I take race and I align it with socioeconomics, and I account for the student who's coming to me with every advantage in the world, and you can call it race-based and say that's entitlement, or you can just say it's that kid who comes with a greater socioeconomic base. So they've been to preparatory schools, they've had private tutors, they have a substantial advantage over an inner city student whose parent is working 3 jobs and is not there to work with them for homework, right? So if I look at that whole student and say race out of the picture, this entitlement kid is not gonna get as many points toward their academics. Not that they didn't work hard for it, but look at all of the support that they were given to do so. And let's compare that to the points that I may give a student who, despite the fact that they did not have preparatory, they did not have a greater number 2, and that I can balance it then. I can say this kid will be just as successful as this kid. But if I don't use some kind of system, this kid will get the advantage, and this kid will not, even though they equally have an opportunity to be successful. And I think the point in this is race has been used anyway. It just hasn't been accounted for because we've looked at it as entitlement, and affirmative action is a way, in my opinion, to balance that. Entitlement on this end, affirmative action on this end equals the playing field. So I think the question is going to be, how can we deal with this so that it's fair? And the Ivy Leagues, in my opinion, have the best formula, whatever that is. If it's a trade secret, let them keep it if it's working, because it seems to work.
Yeah, trade secrets released though. They're now in open court. So.
So it works to serve what ends. What legitimate state purpose does the formula serve? Is what I'm thinking about.
Well, the argument in the Harvard case. One second. Right, the argument in the Harvard case is not that it's failing to serve diversity. They get a diverse class, right? Harvard's actually pretty balanced, right, in terms of numbers. The argument is that it disadvantages certain groups, particularly Asians, right? Because if you have X number of seats in a class, 100, by giving a leg up to one person, you are giving a leg down to another person. And if you read Justice Alito's dissent in the Fisher case, he talks a lot about the discrimination against Asians. That's the angle that Ed Bloom chose for this litigation. Yeah?
I have 2 questions. One is just a clarification.
You said on the suspect classification on number 3, you said there's a presumption of unconstitutionality?
Oh, this has presumption of liberty, I'm sorry. Which is basically a presumption of unconstitutionality.
Okay, so we can use either one of those.
Yeah, usually I say presumption of liberty, but I think you can use either one.
Okay, and the other question was, how is it viewed as a, you said, gosh, I can't even remember what you just said. You said leg, it is a leg down for someone else? Is that what you said?
Well, if you have a fixed number of seats in a class, right? You only have 100 seats in a class. By giving an advantage to one person, it's disadvantaging the other.
Okay, my only question, or my only, I guess, point to that is, I don't understand the complaint when you have historically had 100 spots, and now someone else has the opportunity to get a little 8. What's the problem? So because someone else finally has a seat at the table and the ability to get one of the spots, you're counting that as a leg down. But as she was kind of talking about the level playing field, how can it be fair that you historically have had all of these seats and now other people get to come to the table and you have a problem and you're seeing it as a leg down, when really it's just that it should have been balanced all along. It should be equal representation all along. There shouldn't be there's not a disproportionate amount of intellect out there. There's a disproportionate ability to get to the positions that will recognize that intellect. And so I don't understand the leg down thing, because it really just seems like balance. It seems like finally we're on the same start.
So this just one second. So this goes to the Marshall dissent, right? Is the purpose of affirmative action to make up for past inequality? And the court rejects that. But one of the upshot is, if the purpose is to make up for past inequality, why should an applicant who was born in 2001 pay a price for something they never did themselves? And the response to that is because they benefit from it, perhaps in other respects, based on who they are. So there are back and forths about this question, right? But one second, I promise. But the issue in the Harvard case is Asians have also had a history of oppression, perhaps not as bad as African Americans, which gets to the question, how do you rank different races, or do you not rank them and say that all racial equality is equal? Yeah, Kanisha, and then Janice, and then Marco.
I was fine till you said about how do you say that someone who's a year old or whatever, right? So I struggle with that, because that works both ways. Then how do you now today say that teenage, black teenage, or whoever, that's not one, and say that they ought to have the same issues now, or you are going to label them based on whatever issues you have had with their past, with their ancestors. So, that's 6 in one hand and half a dozen in the other. You say, how is it fair that you, some child, a white child growing up now, shouldn't have to pay for things they had nothing to do with? Then I would say the same about my son and nephews. Why are they paying for things that they didn't do? So that's a weak argument. That's a very weak argument. Because I would venture to say that one has it way worse than the other, because you still have privilege on this side and you have a kid who can't walk down the street and did absolutely nothing on this side. It's a horrible argument.
Okay, Janice?
Well, the 100, I'm sorry, I was eating some of her stuff. The 100 seats argument, I guess, as I was reading this, that legacy is affirmative action in a sense as well. And so if you don't have an issue with legacy, and that's an historical advantage, then if you're going to do away with affirmative action or strictly scrutinize affirmative action, then you have to strictly scrutinize legacy. You can't pretend, you can't ignore it.
Does legacy violate the 14th Amendment?
Well, if it allows an advantage for students to get into, say, elite schools because of their lineage, then what's the difference?
So do you think but I want to make this point. Does, because it's one time, does having, by legacy you mean an ancestor of yours went to the school, right? Does that impose a suspect classification?
In a sense, if historically in the U.S. you've had we've had race issues from slavery leading up until now. So yeah, I mean, if you look at it from that perspective, you have to look at it from a historical perspective. You can't just see it in now in the era of the wrinkles court. You can't see it now. You have to look at it historically. So historically, if there has been no access, there has been one group that have enjoyed that the privileges of legacy, and that is something that that would advantage generation to generation to generation. So my argument is, if you look at affirmative action, you can't take legacy and put it in a separate box, because it is creating a position where certain students, because of their heritage, because of their lineage, they have an advantage to get in elite schools.
So I think you should file a lawsuit arguing that legacy programs are unconstitutional.
Or we could just leave affirmative action alone, and then we're okay.
Indeed, Harvard, the trial from what you follow so far, legacy is the most important factor by a long shot.
Yeah.
By a long shot. Mia, you next?
So in Grutter, the 5, who was that, O'Connor?
Yeah.
She said that, I think it was in reference to the statistical analysis, the person who brought up all of the facts, they said that race wasn't the predominant factor in the calculus. So if it is a factor, but it is not the predominant factor, but in terms of like, I guess I'm trying to figure out in context how, if that would be okay if it was like, if it was 33%.
Well, and this goes back to the critical mass point, which I do want to address. Justice O'Connor is content to defer to the university.
That's a good point. Thank you.
In Fisher 1, I'll segue to Fisher, right? In Fisher 1, the court says, no, we can't defer to the university. And then about a year and a half later, in Fisher 2, they say, we'll defer to the university. So the upshot of this is that affirmative action is not a neat fit for strict scrutiny. Because generally with strict scrutiny, the court takes a microscope to the government's justifications to look at every last thing. And here they say, well, it's good enough. We don't need to know all the dirty details. We don't need to know how the sausage is made, so to speak. Justice Scalia had this great opinion once where there was actually a case. So there's an expression, legislation's like sausage. You don't know how it's made. There was actually a case involving how you make regulations about sausage. It was a great case. You don't want to know how one's made. Yeah, exactly. You don't know how it's made. So it's better not to know. I don't eat sausage, but it's not kosher. But the question becomes one of deference, right? Do you have to put the admissions director under oath to testify about how, in fact, they're going about their program, right? When they say what a critical mass is, they need to give evidence of what that actually means. In the Fisher case, I think it was Chief Justice Roberts asked, how can you know if you've ever achieved your critical mass? And the lawyers just sort of bobbed and weaved and didn't want to answer it, because the second you give a number or a year or a metric, okay, we'll get to that point, it's like, okay, no mas, no more. So you don't have that sort of specificity. So to Mia's question, it's about deference. I think that's basically the point of Justice O'Connor's opinion, that universities have an obligation to have educational missions. They serve an important role, and the courts aren't going to scrutinize and second guess what they're accomplishing. And I think that's the big difference in the majority and the dissent. All right. So any questions on the Grutter majority? We'll get to the dissents in a minute. Any questions on the Grutter majority? Yeah, this one came, I think that was it was 2003. I remember when this came out. This was a huge case, very important. Because this case could have just easily gone the other way. And the court could have said that even neither the Michigan undergraduate or the Michigan law school is okay. Could have just easily gone the other way. All right. Anything else in the Grutter majority? All right, Dusty, let's talk about Justice Thomas's dissent. And I'll preface this. Justice Thomas is in some of a unique spot. He is he had a upbringing that was quite poor. His father left him when he was quite young. He was raised by his grandparents. Grandparent not well educated. He lived in a house in Georgia with no electricity most of the time. Grew up in the segregated South. Went to Holy Cross. Then went to Yale Law School. And he very much regrets the fact that he was admitted under affirmative action policy. For a number of years, he put a cigar label on his diploma from Yale saying it's worth $0.25, his diploma. He very much regretted it. In fact, he didn't even visit Yale until about 5 or 6 years ago. He eventually came to terms. And he takes a position on affirmative action that he alone takes on the court. And now on the court you have Justice Sotomayor, who also went to Yale Law School, I think maybe 2 or 3 years after Thomas. They were pretty close in age. And she is very proud of her admission by affirmative action. Now, I don't assign this case anymore because I have too much reading. But there was another dissent by Justice Sotomayor in a case called Schuette, Schuette. Is in your supplement? Oh, I didn't make you buy the supplement. Okay. It's mentioned, yeah. I don't make you buy it. There is a supplement, but I don't make you buy it. It's $30. You don't have to buy it. But it's called Schuette. I think we referenced it in the reading. That's right. And this was a case about whether Michigan could abolish affirmative action by statute, or by constitutional amendment, I'm sorry. And if you want to get a contrast with Justice Thomas, read the Sotomayor dissent. It's long, and I can't give you more pages to read. We have to trim the book every couple of years. But it gives a good contrast. So, at least, Dusty, walk me through. I'm sorry. Yeah.
How do you know you got into school based on affirmative action? Maybe I'm the only person who don't know the answer to this question. Am I just supposed to make that assumption? Because I thought it was like GPA, test scores, graduation rate.
You don't. Students don't.
So how do you know that you got into school based on affirmative action?
I think Justice Thomas. One second, Jessica. I don't know if Justice Thomas ever had a letter saying you were admitted by this policy. I think he's fairly confident he was. Maybe he was, maybe he wasn't. But even if he wasn't, he feels that the presumption is that he was, and that people think he was admitted for that reason.
So he didn't think he was qualified?
No.
What that sounds like.
I don't think he, no. That's
qualified, but he was upset that he was admitted based on another reason other than his qualifications.
just one at a time. Just let him speak. Yeah.
Sort of feel the same way. I mean, I don't want to be admitted just because I'm black anyway. I strongly feel that way. And I've always felt that.
Guys, just one at a time. Just please. All right.
My question was, so I gotta, like, I still, do you get a letter? Do you get your diploma, your degree, your diploma say?
Guys, just one at a time. No, Marcus, just one at a time, please.
Is your degree or some say, graduated,
Guys,
comma, cum laude, comma, affirmative action? Because I don't understand how you know.
Right. So let me address, guys, one at a time, please. So let me, and I'll get to second agent, I promise. So let me address the Thomas position. Justice Thomas feels whether or not he was admitted through affirmative action, and even though his diploma doesn't have any sort of insignia to that effect, people presume he was admitted for that reason, and that diminishes, in his mind at least, the value of his education. That's why he puts a cigar sticker on his diploma. All right, now Adrian.
So I just find it curious, and I don't know if you have knowledge of this or not, but Justice Thomas was concerned about the fact that he felt that people assumed because he was a black man at Yale that got into Yale that it was due to affirmative action. But he didn't regret his appointment to the Supreme Court. However, Joe Biden has stated that he didn't push the other women who came forward because. So I find it odd that he was not concerned about affirmative action placement, but he was concerned about a Yale placement in which he may have gotten in for that purpose, maybe, I have no idea, but he had to earn that degree. And I find it odd that he would regret something that he earned. So I didn't know if you had any insight.
Well, one of the more dramatic moments of the Thomas hearing was when he described the proceedings against him as a lynching. And he injected the racial element into the proceeding that he was a black man being accused of sexual harassment. And he described it as a high-tech lynching. Where's your hand?
That just makes him full of crap. I mean,
Full of crap. Want to rephrase that just a little
well,
bit?
he's a Jew. I mean, when he did that, I don't know why I keep talking.
Some professors ban food in class. I never did that, but maybe I should. Maybe pizza delivery at least.
That,
No, I'm okay.
I mean, what you just when he did the high tech lynching line. So he used race when it suited him, and so I think it really his issue with the cigar on his diploma, because I did read that a while back. It's full of crap. I mean, it really is full of crap, and it may be a way to justify whatever his thinking is, the perverse thinking.
Just don't. I'm sorry, I have to interrupt. The full of crap, and that's let's just use. Just describe what you're saying, not just full of crap.
But that's what I'm saying is that if you
mean hypocritical? Is that the word you're looking for?
No, you're using not even hypocritical. I don't even know if you would even consider it hypocritical. It's opportunistic.
Okay,
because
that's fine.
You're using race when it suits you, when you need it, and then at the same time, denying, affirmative action, because affirmative action is just not about color. It's not. That's not what it's about. But denying other people that come behind you, because as Adrian said, if you did get into affirmative action during the time that he was living, during the time where he was college bound, he did have to get out of Yale. He had to earn his way out of Yale, and he did that. So that his issue is a self-hate issue, and if he truly felt that way about his diploma or about his education, he would never have used race in his confirmation for the seat. He would never have used that as a tool.
So let me just take a step back and address this more broadly. People are complicated, right? People are very complicated. People often hold a wide range of beliefs that are in tension. And it doesn't make them bad people. I'm sure if I put everyone in this room under a microscope and asked you to justify every one of your views, you'd flunk. I would, right? We all have certain beliefs. And if you learn nothing else in law school, is to approach things, right, generally with a presumption that people are trying in good faith to figure out questions the best way they can. So on the Supreme Court, you have a 5-4 decision that's very bitter, right? I don't think that's because the majority or the minority is wicked or bad. I think they have profound disagreements of law. And there's a reason why before every sitting of the court, they shake each other's hands to establish that there's a common bond among them. And we study the Supreme Court justices if they're these sort of oracles, these sort of people who should be held up to exemplary standards. They're people. And people often react differently under different circumstances based on who they are and where they've been. Now, you think I might be full of crap, to borrow the phrase, right? I might be totally off base here. Fine, think I'm wrong. But you're lawyers. And you're going to have to make arguments in court based on the presumption that these are judges deciding on law. That if you write in any brief or any argument to a court and you say, Your Honor, I think you're a wicked person, you're going to be laughed out of court. So whether or not you agree with me, I really don't care. But a skill set you must have in law school is the ability to presume that judges are acting in good faith, and I do think judges do act in good faith, and then act accordingly and make arguments based on their grounds. So perhaps the criticism for Justice Thomas is not about Anita Hill or not about his cigar sticker diploma, but about the fact that, I don't know, we have the Freedmen's Bureau of 1866. I think a huge criticism of Justice Thomas, which he's never addressed, is at the time of the framing of the 14th Amendment, there were affirmative benefits given to the freedmen. We had an entire bureau called the Freedmen's Bureau. They handed out benefits to people who were recently freed from bondage. He's never once addressed that. Not once. And I've flagged this point for the last 7 or 8 years. I was hoping he didn't fish or he didn't do it. So to the extent that things are hypocrisy for Justice Thomas relevant for this class, that's it. If you notice, Justice Scalia didn't join part of Thomas's opinion, the part about the Frederick Douglass part, right? Yeah, he didn't join the introduction. So there are, I think, grounds that the justices don't explain themselves well. And I think that's a fertile ground for us to discuss in class. Okay, I saw a few other hands. I forgot where they were. Yeah, yeah.
So, yeah, I've learned in law school about hypocrisy because there's a lot of that. And I'm not sure how you can look at this to say that the majority of the justices have had good intention with many of the opinions that they've written. And as far as the whole Thomas thing, I even wrote in my book, I think it's funny. If he doesn't think that affirmative action is the reason he's on the bench, because there's only ever been one. So there's that affirmative action spot. So how I agree how you get upset about a diploma that does not say when you hold an office that clearly does say. So I don't know how you get around the fact that that is clearly opportunistic, hypocritical, or that people change their opinions. I've also learned, I've always thought, and this has solidified for me, you have to stand for something, and you plant yourself in that, if that is your belief. You are not wishy-washy because you get criticism because people do not agree with you. But that's truly what you believe, that's what you ought to stand in. Many of the opinions in here, they're not based on law. We've talked about that. They're people's opinions, so it's difficult to think that you have a bench of justices who are making law-based decisions when it's very clear that they don't. I mean, Tawny, whatever his name was, he's like the perfect example. All that crap he wrote about.
Just not crap. Yeah, just
well,
yeah.
I mean, that's what it is.
Okay.
About he made it up. There was no legal foundation for that argument. And there have been quite a few that are like that. So I don't understand how the argument is made that. I get that there are people, I agree, because people are hypocritical. We have some of that. Yeah, she says that they're political. But I don't get how.
Again, whether you agree with me or not, I don't care. It's largely irrelevant. What you should know, though, is you're going into a profession where you have to at least pretend to care. I care about your practice as lawyers. That I do care about, right? Whether you agree with my points, I don't care. In other words, maybe you think originalism is crap. Maybe you do. There are now 4 or 5 justices who favor originalism. So if you're making an argument to a court, you have to adopt what the law is. You're entering a profession that has a lot of unfair stuff. A lot of things you think are hypocritical. There are a lot of rulings that I think are insane that you probably like very much. And there's some rulings that I probably hate that you like, and the other way around. You're in a profession where your personal opinion is lovely to discuss in this class, which is why I love law school. We can have these discussions. But what I think you should take away is you're going to have to make modalities of argument, right? So my only time to interrupt people is if I sense in class that the argument's being made in a way that's not conducive to what I think you'll have to do eventually, right? That's my only objection. Otherwise, you guys can say whatever you wish. All right. I saw other hands. I don't know who was up.
I had a question.
Yeah.
Back on the Thomas dissent.
Yeah, sure. I don't think we've even discussed it yet, but we'll get to that.
Oh,
So yeah.
then I can wait.
Give it to me.
Okay. So he talks about the exclusionary or selective process of the admission system.
Mm-hmm.
Is that essentially kind of what you're saying in the concept of by giving a person a leg up, you're taking somebody else out of the pool?
Yeah, I mean, that's the fixed number of seats approach, right? You have 100 seats. But let me just walk through Thomas. We're running a little bit short on time. Justice Thomas makes this point in Fisher, and he makes it in Grutter, so I can merge them a bit, that strict scrutiny has been watered down for affirmative action. That if we talk about what's a compelling interest, does Michigan have a compelling interest in having an elite state university or state law school? He says absolutely not. right? Not every state has a law school. Most states don't even have an elite one. Alaska has no law school. It's the only one in the union, right? So he says that there's no compelling interest. Is the holistic approach narrowly tailored? We don't know, because they don't tell us what they're actually doing. So under any normal standard, Justice Thomas says, this doesn't fit strict scrutiny. So instead, the court waters it down, or perhaps applies something very different. Okay. But again, I do think Justice Thomas should be faulted for not engaging with the original aspect of, at the time of the 14th Amendment, there was a lot of race-based preferences. Now, that doesn't resolve the issue, because maybe those preferences were justified in the 1860s, but at some point in time, whenever it is, they become non-justified. He could make that argument, but he hasn't made it. But I think he should at least engage the historical argument. All right, so any other questions on Grutter or Gratz? And we'll have to go through Fisher fairly quickly. Anything on Grutter or Gratz? All right, Gerald, you want to give me the facts on Fisher? The facts are the same. Fisher 1 and 2 doesn't really matter. But the facts on Fisher, please.
So this was a case arising out of application for the University of Texas.
By the way, so people hook them. I'll interrupt you. So by the time Fisher got to the Supreme Court, I think on the second go-around, at least on the first, she had graduated. Oh, actually, I had a student who went to high school with her. She sat right there. I don't remember her name, but she sat right there in the second row. It's weird. I know people sip. I don't remember their names always. It's a very strange thing. Because when you move around, it drives me bonkers. But she sat right there. And she went to Sugar Land High School with Abigail Fisher. Now, by the time this case got to the court the second go-around, she'd graduated from LSU. Why was the case not moot? This is an important point. She was suing for a refund of her application fee, and that was the injury. Now, some inside baseball. Why didn't UT just refund her application fee and moot the entire case? I'm sorry? They wanted the Supreme Court to rule on this issue. They were taking a risk. And they took a risk, and they wanted the court to rule on this issue. So my own position is I think the case was moot. Right? It's a weird situation where you have 4 years to bring a lawsuit, and then you can't bring it anymore. There's some exceptions to mootness. For example, an abortion lasts 9 months, but it's called capable of repetition. You had evading review because it keeps happening again. So they fixed this with the next round of cases. With the Harvard case, it's not based on one student. It's based on a class of people, an organization. So they get around that one person. So I think there was a second plaintiff. It was Abby Fisher, and this one of their student. She dropped out of the case because she went to SMU Law School, and she did not want to be the named plaintiff in the case. So it was just Abby at the end. All right, Gerald, go ahead. Please give me the facts from Fisher.
All right, so the University of Texas, they used 3 different programs throughout the years for their admissions. The first of the program was used some years between 1996 and 1997, and it considered 2 factors: the numerical score reflecting an applicant's test scores and academic performance in high school, and the applicant's race. Now, this one was held unconstitutional by the United States Court of Appeals for the Fifth Circuit. Then the second program was adopted to comply with the Hopwood decision, which you mentioned earlier.
Yeah.
That struck down one of the races. But so this one, they stopped considering race in its admission and substituted instead a new holistic metric of a candidate's potential contribution. It was a personal achievement index.
Okay.
It measured a little bit of everything, leadership, work experiences, other special circumstances that might give insight into whatever your background was. And the Texas state legislature responded to this by enacting the top 10% law, which was just basically if you graduated within the top 10% of your high school, you automatically gain acceptance in any of Texas public schools. And then there's a third one, which is the 2004 program, which the university reverted.
That was about right after Grutter. Basically, the day Grutter was decided, they said, all right, we're going back to affirmative action, right? We're going to do it again. They go on the 2004 one?
Right, so in this one, there was, this program is what's, being argued here.
Hmm?
So it planned to resume race-conscious admissions, And they brought it forward in some internal document entitled Proposal to Consider Race and Ethnicity in Admissions. And this proposal relied in substantial parts on basically studies of different undergrad programs. And it showed that a few of these classes had significant enrollment by members of racial minorities. So yeah.
Okay, I think you gave me good stuff. Okay, so you have several different programs, right? Initially, UT had an affirmative action policy. The Fifth Circuit declared it unconstitutional. The Supreme Court declined the case. So again, before Grutter, the Supreme Court basically punted on whether this was required for one reason or the other. Okay, then after after the Hopwood case, UT adopted this top 10% policy, which I'm sure you're all familiar with, where if you're in the top X percent, it's not always 10, it fluctuates year to year, but if you're in the top X percent of a high school class, it's 7 now? Thank you. Top 7% of your class, you're guaranteed admission to any state university, whether it's A&M or UT or wherever. Texas Tech. What?
Oh, just said Gig'em, sorry.
Gig'em. There you go. Okay, very good. So, that policy, though, again, was premised on the fact that most high schools have fairly stratified racial makeup. So if you have top 10% of a school in a black neighborhood, it's going to be mostly black kids, and a top 10% of a school in a Hispanic neighborhood, and the top 10, et cetera. So Abby Fisher did not make the top 10%, and she challenged her admission. She went to Sugar Land High School, which is a fairly selective high school out in Sugar Land. Okay, so first off, they weren't seeking to overturn Grutter and Gratz, and they made that very clear, right? They weren't seeking to overturn it. Instead, they were saying that UT's approach was not holistic enough. I only have a few minutes left, so I'll summarize it. In the first version of the case, Fisher 1, as it's called, the court reached a very strange compromise. And there's a lot of backroom dealing about this. And there's a really good book by Joan Biskupik. I encourage you to read it. About Justice Sotomayor. She's an excellent biographer. She has a book kind of about the chief next. She's one of my favorite biographers. So apparently the court was originally poised to declare the UT program unconstitutional. Recall that Justice Kennedy dissented in Grutter. It was O'Connor in the majority. O'Connor was replaced by Alito, who was more conservative. However, apparently Justice Sotomayor asked them to reconsider it, and they reached this sort of strange compromise. They said, well, we think it's unconstitutional, but we're going to remand it back to the lower court just to take another look at it. Justice Ginsburg wrote a brief concurring opinion saying, she wrote a dissent saying that this is nuts, we should uphold it anyway. And Justice Thomas wrote a very, very long opinion, which I don't have time to go over now, where he equates the use of affirmative action and racial classifications by UT with the sort of racial classifications used by the segregationists in Brown. I wish I had time, but I don't have time for that. Okay? So then what happens next? It goes back to the lower court. The lower court, surprisingly, in my mind, upheld the policy. Basically said the exact same thing. They were basically daring the Supreme Court to reverse them. There's no other way of looking at it. They were daring the court to reverse them. They knew they were they knew they were in trouble. So then it goes back to the court. And here the math is somewhat weird. There were only 8 justices because Justice Kagan was recused. The conventional wisdom is that she advised the Obama administration on it while she was Solicitor General. That's the reason why. So you had 8. So in a best case scenario, right, it was a 4-4. Affirm the lower court, but set no precedent. In other words, UT's policy is fine, but that doesn't mean anything elsewhere. The case was argued with 8 members of the bench. Justice Scalia was there. He was very active. It was fairly obvious which way he was going to vote. And then we get to February of 2016, where Justice Scalia passed away unexpectedly here in Texas. At that point, they were down to 7. And we don't know exactly what happened. We'll figure it out maybe in the future when the paper is released. But the vote came out 4-3, in which the court said, well, we'll still defer to the UT. We're not going to scrutinize this more carefully. And they upheld the policy. Again, it's a very strange justification to go from Fisher 1 to Fisher 2. It doesn't make sense unless you get the Scalia death. That's the only way this entire case makes sense, which is why I put that little excerpt between the cases. After Fisher 2 was decided, Justice Ginsburg gave an interview where she said lots of things about lots of people, but she said that she thought that Fisher 2 would be settled, and even if Justice Kagan comes back, she'll vote the same way, and she wasn't worried about that outcome. Now, I think Justice Ginsburg was expecting Hillary Clinton to win the presidency and for Merrick Garland to be the next justice. That did not pan out. So now we have the Harvard case, which I think will be I don't know if the court will take the Harvard one. There's also one at UNC. So this is an area that's very much in flux. And just to recognize this. I don't know that then Judge Kavanaugh had any affirmative action cases, but I don't know if he'll be as flexible on this as was Justice Kennedy in Fisher 2. So we'll probably see a case from either North Carolina or Harvard or maybe another university in the next couple of years. Now, the hard part for you is you guys leave. You move on. You say, Josh, what happens? What happens? I don't know what happens. We're in a change in court. And I think a lot of areas that were somewhat in stasis with Justice Kennedy now are destabilized because of the new court coming up soon. So I don't know where this one leads. But at least for now, the court has upheld the sorts of policies that UT Austin used. After I think this Harvard case opens up and people study the record, I think there'll be a lot new channels of attacking the constitutionality of these policies. Any questions on Fisher 1 or Fisher 2? Yeah, Mia?
So, is it that the university's ends are concrete? Like, as long as we know what their goals are?
What are UT's goals here?
Educational diversity, something
Well,
like
specifically, they're seeking a critical mass, right? It's not just educational diversity. They need a critical mass of minority students to obtain those benefits.
I'm not trying to be cute or cast any judgment or crass, but like, so is it as long as they use words? Because I don't...
Use words. What do you mean use words?
I mean, I don't understand what critical mass is.
Yeah, and I mentioned this part earlier. If you
I know what critical mass is.
Critical mass means if you have a certain number.
That's a number.
But then when you get to number, you get to quote Mbaki. So if you want to look, guys, just back up in a second. We're not done yet.
That's a threshold.
So if you want to look at a skilled advocate, go look at the oral argument in Fisher. And when the Chief Justice asks you, what's your critical mass, to actually dodge and bob and weave and not answer the question is very good advocacy. Because they know the second they answer that question, they're done. Right? The second they answer that question, they're toast. So again, it's about deference. It's basically saying, well, we know you can't give us an answer, so we just want to ask the question. Right? That's the basis of O'Connor, and that's the basis of Fisher 2. You know, we don't want to know because if you tell us, we're going to have to declare it unconstitutional. Well, just okay not knowing. All right. Anything else in Fisher 1 or Fisher 2? So let me bring this back. Generally, you're going to apply the strict scrutiny framework as it's stated. With affirmative action, though, it's not a perfect fit. And this is not the only instance. The courts watered down strict scrutiny in the First Amendment context and elsewhere. So this is not anomalous, right? But you have to keep in mind that what exactly the compelling interest the government is trying to achieve, and keep in mind this concept of critical mass, which no one ever defines what that actually constitutes. Anything else? I will see you all on Wednesday. Thank you.